Good afternoon, everybody. I'd like to acknowledge the traditional owners of the land where I'm located today, the customary people, and pay my respects to their elders past, present and emerging. And thank you very much, Professor Rimmer, for the invitation to speak today, and apologies everybody for not being there in person. My daughter's very ill this week and it was too difficult for me to get to Brisbane today. So this paper is about the International Court of Justice's advisory opinion on climate change, and I've called it unlawful by definition for reasons that I will shortly explain. What was this advisory opinion? So the International Court of Justice handed down its advisory opinion on the legal obligations of nation states with respect to climate change on the 23rd of July this year. And this was in response to a request from the UN General Assembly for this advisory opinion, and specifically these were the questions referred by the UN General Assembly to the International Court of Justice. As you can see on the slide, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And what are the legal consequences under these obligations, where the states, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to states, in particular small island developing states, which, due to their geographical circumstances and level of development, are injured or specially affected by or particularly vulnerable to the adverse effects of climate change. And secondly, with respect to people and individuals of present and future generations who are vulnerable or affected by the adverse impacts of climate change. So that was how the questions were framed, and I'll talk more about the process which led to the UN General Assembly referring these questions to the court in a little bit. Now, in short, the findings were as set out here, that nation states have obligations pursuant to climate treaties like the Paris Agreement, the Kyoto Protocol, the UNFCCC, but also obligations pursuant to other environmental treaties like the Convention on Biodiversity, for instance. They also have obligations under customary international law, and this was a really important part of the advisory opinion, and in addition under international human rights law. So obligations arising from all these different areas to adopt all necessary measures to protect the climate system, but keeping in mind that principle of common but differentiated responsibilities and taking into account respective capabilities. Now, these obligations extend to regulating conduct of private actors, so regulating the conduct of private actors within the jurisdiction of these nation states. So this advisory opinion directly impacts upon corporations. And if states don't meet these obligations, they may be required to pay reparations or compensation to injured states or even individuals who bear the brunt of the consequences of their actions and or omissions. So there was a trio, if you like, of advisory opinions handed down within a very short space of time, of which this one was one. So there was this advisory opinion handed down by the International Court of Justice, but earlier in fact, the year before, in 2024, the International Tribunal for the Law of the Sea had handed down an advisory opinion with really similar findings, that nation states have an obligation to protect the world's oceans from the impacts of climate change by taking these necessary steps to reduce greenhouse gas emissions. And just a few weeks before the International Court of Justice handed down this advisory opinion, the Inter-American Court of Human Rights had handed down an advisory opinion in which the court acknowledged the obligation of nation states to protect human rights at risk from climate impacts, including a right to a safe climate. So these were all really important advisory opinions handed down within a very short space of time of one another. So I will not so much focus upon the findings of the court, which I've just mentioned. I want to focus upon the outcome and implications of this advisory opinion, and focus in particular upon three different aspects which I think are very important. And the first of these is that it was a youth-led initiative, so more on that shortly. And the second aspect that I want to talk about is a distinction that has been adopted by a number of commentators, but is originally thought to have be found in the work of Richard A. Falk, the distinction between globalisation from above and globalisation from below. And I'll look at where the advisory opinion fits within those two categories. And finally, I want to come back to this term, unlawful by definition, and what the advisory opinion means in terms of the constraints and limitations of law in addressing an existential crisis like the climate crisis, and what conclusions we can draw from the advisory opinion about those sorts of limitations and constraints. But in terms of significance of the advisory opinion, obviously there's been quite a lot already said about how momentous and important an event the handing down of the advisory opinion has been. For instance, these are just some of the things that have been said: that it will reverberate in courts, parliaments and boardrooms the world over, that the days of impunity for the fossil fuel industry are coming to an end, and similarly the era of climate impunity is over, and the court has reshaped the global fight for climate justice. So that's just a small selection of some of the things that have been said, but the advisory opinion was greeted with enormous enthusiasm and excitement by everyone striving for climate action around the world. It's already being cited and applied in climate lawsuits. For instance, the European Court of Human Rights' recent decision in a rather long legal saga, an action brought against the Norwegian government, which was also a youth-led initiative by Greenpeace Nordic and others. And just we're currently, of course, in the concluding days of COP30, the opening of COP30 in Brazil, just at the beginning of last week. The UN special rapporteurs, members of working groups and independent experts all joined together to call upon states to negotiate in good faith in accordance with the ICJ advisory opinion on state obligations on climate change. So it is a very solid piece of ammunition that can be used in all sorts of contexts to argue for more climate action. In terms of Australia specifically, there's obviously a lot of grounds for international criticism of Australia's support of and reliance upon fossil fuels. And the Vanuatuan Climate Change Minister has already jumped in to talk about Australia's position, specifically in relation to approving that extension of Woodside's Northwest Shelf gas project as being an internationally wrongful act under international law, given the ICJ advisory opinion. So who knows what we will see in the future, but a number of people are predicting that there will be lawsuits against the Australian government due to its stance on support for fossil fuel projects, with the basis for those actions being the findings of the International Court of Justice. So coming back to something that I've already mentioned, the fact that this was a youth-led initiative, I just want to unwrap the backstory to the advisory opinion, because it is so very interesting and significant, particularly for educators like I am and many people here are, that in fact the origin for this initiative lay in the classroom, that there were a group of final year students at the University of South Pacific who were asked by their professor to brainstorm courses of action in international law which would best assist the Pacific Island states with respect to the climate crisis, and to write a legal brief once they had come to the conclusion as to the best course of action for the Pacific Island Forum leaders. And they did this. They called themselves the Pacific Islands Students Fighting Climate Change. And they took their idea to the Vanuatuan Foreign Minister, who supported it, who said, yes, this is a great idea. Let's see what we can do in terms of getting this ICJ advisory opinion. And as we know, as already said, the General Assembly did adopt a resolution to take those questions to the ICJ and get some advisory opinion handed down by the ICJ on those questions. And Vanuatu led this initiative in the General Assembly of the UN, but there were over 100 other nations that also sponsored it, including Australia. So it's really interesting that this was a student-led initiative, and the president of the Pacific Island Students Fighting Climate Change, Cynthia Honui, presented very powerful personal testimony before the court in December of 2024 during the hearings. And when the advisory opinion was handed down, she said, "This is a victory forged by Pacific youth, but owned by all. We pushed the world's highest court to listen, and it did. Now we move from legal words to living change. Young people will make sure this ruling cannot be shelved or spun." So not only leading the charge in terms of getting the advisory opinion, but presenting this commitment that young people will ensure that the findings of the International Court of Justice actually have concrete effect. So it's important to know that this, as a youth-led initiative, is part of this whole burgeoning phenomenon of youth-led climate lawsuits and legal proceedings against governments, which began in 2011 with the US Children's Trust lawsuits, but now there's youth-led climate lawsuits in all sorts of jurisdictions and forums, including international forums like the European Court of Human Rights and the UN Committee on the Rights of the Child. And the symbolic importance of this youth-led litigation can't be understated, because we're seeing children take on their political representatives in courtrooms, and some of these, children and young people, some of these litigants are very young, and probably the youngest being a fetus in a South Korean lawsuit. And just important also to note the two mentions of future generations in the way in which those questions were framed for the court. So that's the first important aspect of the International Court of Justice advisory opinion that I want to highlight, that it's youth-led. The second important aspect arises from these two categories, globalisation from above and globalisation from below, which, as I said earlier, have been attributed to Richard A. Falk. So what he said globalisation from above is this domination of transnational market forces and significant co-optation of state power. So the role that these multinational corporations play in the international arena. And globalisation from below, however, is the ideas of a global world order based on shared values, which include economic, social and political justice and environmental protection. So all the stuff that we see endorsed in conventions and treaties that are designed to promote social justice and environmental protection and protect the climate system. The problem is that these two forms of globalisation are frequently at odds with each other. And I just also want to mention that Hilary Charlesworth, one of the 15 International Court of Justice judges who handed down the advisory opinion, actually wrote a paper in 1997 in which she adopted these categories of globalisation from above and globalisation from below, the paper being called Dangerous Liaisons. So this advisory opinion from the ICJ, the principal judicial organ of the United Nations, is a really good example of globalisation from below, and specifically globalisation from below in pursuit of climate justice. So one of many multinational attempts to protect the climate system, to protect climate vulnerable nations, to protect the human rights that are associated with a safe climate. So globalisation from below. But the court didn't ignore globalisation from above and the role that multinationals and specifically the carbon majors, the major producers of fossil fuels, play in this accelerating catastrophe. So here are some extracts from the advisory opinion, which were pretty important in that respect, that nation states have to rein in the activities of public and private operators within the state's jurisdictional control in order to meet their due diligence obligations under international law, that the failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licences, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to the state. And a state may be responsible where, for example, it has failed to exercise due diligence by not taking necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. But as a consequence of the fact that we have two world orders, one encapsulated by globalisation from above, one encapsulated by globalisation from below, it is going to be pretty hard for nation states to rein in the activities of multinational corporations without there being consequences. And I'm thinking here of investor-state dispute settlement clauses in international free trade agreements, which enable corporations to take nation states to international tribunals to get compensation should they be in a position where the nation states are attempting to do as the ICJ has required of them, to rein in the activities of these multinational corporations by essentially turning existing fossil fuel projects into stranded assets. And there could be an enormous amount of money being sought in compensation claims the estimate here from this 2022 article being $340 billion. As you can see from this quote, this is something that has been commented on extensively, even though it is secretive, this international arbitration process. And these sorts of cases where foreign investors have already secured enormous amounts of money in the form of compensation create regulatory chill. So just a couple of examples when the Italian government decided to ban new oil and gas projects within 12 nautical miles of its coastline. Rockhopper, a British oil and gas exploration company, was able to get enormous amount of compensation in an award pursuant to an ISDS clause in the Energy Charter Treaty. That award was actually set aside this year, but not because of any problem with the ISDS clause being used in this context, but because there was a procedural issue in those a matter of procedural fairness in that particular situation. And in Australia, we've got Clive Palmer currently having 3 claims against the Australian government for billions of dollars under ISDS clauses in relation to his coal or his thwarted coal projects. So this is completely legitimate in this alternative world order of globalisation from above, and it really does suggest that there's no clear pathway to meet the international climate obligations of nation states while we have globalisation from above as an alternative world order to globalisation from below. And finally, I just want to expand upon this unlawful by definition point. So the ICJ and the ICJ drew upon the International Intergovernmental Panel on Climate Change reports, but also had a private meeting with the IPCC scientists, concluded that climate change is an urgent and existential threat. Now, what I'm interested in is whether any court, even the most prestigious international court, can adequately address an existential threat. And in the final paragraph of the advisory opinion, the International Court of Justice said this is more than a legal problem. This is an existential problem of planetary proportion, and international law has an important but ultimately limited role in resolving this problem, that we need all fields of human knowledge to contribute to the resolution of this problem. And the phrase unlawful by definition it was originally devised by B.S. Chimney in talking about nuclear weapons, but it was quoted by Justice Weeramantry in another advisory opinion on the legality of the threat or use of nuclear weapons. So in this context, or in that context, nuclear weapons were described as unlawful by definition because of the existential threat they pose to the community of nations. And I would argue that fossil fuels are also unlawful by definition for the same reason. And I would also say that the climate crisis and indeed the possibility of nuclear war are both essentially outside law's empire because they are so planetary and enormous in their scope, in their temporality, and in their geographical reach. They look like Timothy Morton's hyperobjects. So where fossil fuels could be called unlawful by definition, I would suggest the climate crisis is extra legal by definition, so outside law's empire, and posing a threat to law itself. So even though as lawyers we might not to conceive of these matters being outside law's empire. It's certainly within the imagination of one of Australia's finest novelists, Tim Winton, in his 2024 novel Juice. This futuristic Australia is very much an extra legal realm where there's no government, there's no courts. Justice just takes the form of murderous acts carried out against the last survivors of fossil fuel dynasties who are hiding in bunkers. And Winton has said this is a vision not just of a disfigured world, but of a disfigured humanity, and that's what he's warning against. So just to conclude, we certainly cannot afford to abandon legal means, legislation and litigation in contending with the planetary crisis of climate change, but I think we need to keep in mind, as did the International Court of Justice, that law is not necessarily enough to address an existential threat, but also keep in mind the very potent and existential threat that climate change represents for the rule of law itself. Thank you very much, everybody.